All right, ladies and gentlemen, boys and girls, moms and dads, it is time. It is time. It is time for your Insurance Corner. Welcome back, everybody. My name is Bill Miksch. I'm president of WDMA Financial Group in Grayslake, Illinois, where we protect your life, we protect your health, we preserve your wealth, and we can guarantee you an income for the rest of your life, and I couldn't say it if it weren't true. Tonight, we are going to talk about legacy planning, estate planning, kind of the same thing. Last week, and I'll get into the tidbits here in a second, folks, but last week we didn't have a show because I was actually doing some estate planning with some clients that we have in Florida and introducing them to things that they need to know, stuff of which we have covered on this show. Some of which we're going to talk about tonight, some of which we're going to talk about in the next few weeks in future shows. In fact, I've been basically traveling for 11 days, folks, and I'm tired. So now normally that's where I little transition to here's Sean, but Sean is on assignment tonight, ladies and gentlemen. So for what it's worth, if you want to take a chance to call the master, you can dial 262-394-6555. That's area code 262-394-6555. That's WLCB 101.5 FM, Slade's Corner, Wisconsin. Sean is on assignment tonight, and so he will not be joining us. So we are able to take calls. And I'm happy to take a call on any subject that has to do with life insurance, long-term care, Medicare, estate planning, disability, retirement planning, et cetera, et cetera. In fact, I've fielded some calls in the last 24 hours, to be honest, with regard to Medicare, and what happens when you retire early, what are your options, and then a tidbit about a client of mine who I've known for 30 years that passed away recently, and we're going to talk about that in just a second. This is 101.5 FM WLCB, Slade's Corner, Wisconsin. Your Insurance Corner is now live for the next hour. We will take you on an excursion. We will make you think, we will make you laugh, and we'll make you pause about certain things so that you can make sure that you and your family are taken care of to the extent that you need to do that. One of the things that I've spent some time with is putting together a PowerPoint presentation with regard to estate or legacy planning. And initially, it was meant for people in the upper income levels, and I'm talking estates worth $5 million and above. But then I realized that as I was putting this together, it doesn't matter if you are worth only $25,000 or $25 quadrillion. Every single topic that's in this PowerPoint could be used by any person, and in fact, for at least two of the three areas that are in this PowerPoint, every single person, if you care, should have one of these or should be thinking about one of these things. And we're gonna talk. We're just gonna do a recap on powers of attorney, and then we're gonna get into wills. No trust work tonight. Trusts are a very complicated, more involved discussion, and there's a bazillion types of trusts that you can do, not just one or two. So we're going to take our time with that. So let me get into the tidbits a little bit. As I said, I've been traveling for the last 11 days. My wife and I started our baseball excursion. So we went to Cincinnati, Ohio, visited with family on the way up in Indianapolis, and then in Columbus, Ohio, where my cousin and his son and daughter and wife live. And then we actually hooked up with Sean at lunch in Cincinnati before we went to the Cincinnati Reds game. and it was good. It was raining a lot in Ohio that day. Fortunately, by the time the game started, the rain had stopped. It was still cold, but it was a good game, and we had pretty decent seats, to be honest with you. And then I was home for maybe 6 hours, and I was on a plane to Florida for the following week, and I had meetings stacked up one after the other. So, and one of those meetings, folks, was sitting with a client of mine who I've been the broker for a long time. And I consider him a friend as much as a client. And part of my job as an advisor is to make sure that my clients are at least aware of the circumstances that they have created for themselves and how to fix them if they want to fix them. I can only bring the solutions to the table, or at least the questions to the table, as to whether or not a client wants to do something or not. But as the old saying goes, I can bring the horse to water, but I can't make him drink. And there's a lot of us. In fact, this conversation came up a couple days ago. I had mentioned about what I was doing with somebody, and they said, well, the rich people are generally taken care of. And I'm like, contraire, most of them probably are not. And so for those of you that are listening, people in my industry thrive on introductions and referrals. I don't like the word referral. It's kind of messy. But I like to be introduced to people, no different than anybody else in my industry. And those introductions, I can promise you, for those of us that are good at what we do, we can probably poke a hole in any person's situation because they don't know what we know. They may have gotten decent advice by an attorney. I did sit with another client a few weeks ago who said, oh, you just need a will. You don't need a trust. And I said, well, why would they say that to you? And they said, well, you didn't have a big enough estate. And then I pointed out that if you had a trust, you avoid probate. And if you put the house in trust, it avoids probate. You can open up the estate the day after you put yourself in the ground, kind of thing. And their thinking was, well, they're an attorney. Why wouldn't they tell us that? And I said, well, I can't tell you what was in their mind. What I can tell you generally is if an estate planning attorney recommends a will, they're not wrong. Smaller estates, you can argue on both sides of the equation as to whether or not somebody needs a trust. But what the person doesn't know is when you pass away, you're going to end up going to probate with a will. It's guaranteed, and we're going to get into that in a minute. So I raised a question for them to go back to their attorney to see whether or not they should do a living trust rather than a will. And that's the kind of things that we do. And advisors like us do this routinely. So let me go into my tidbit section. I want to just chat a little bit about a lady that I've known for probably 30 years. I think, full disclosure, this lady's name is Barb Sable. She passed away in her sleep about a week and a half ago. And the reason I'm bringing this up, folks, is she and I had a conversation about April 24th, and which is, I think, a Wednesday, maybe a Thursday. And she was in great spirits. She and a friend of hers were going to go to Jamaica, and she just wanted to make sure that she had health insurance while she was traveling abroad. And this is the point of the conversation. A lot of you travel overseas and you think if you've got Medicare or you've got your Blue Cross or United Healthcare, Cigna, Aetna, name your insurance company, you're covered. And I'm going to tell you, you might be some coverage, but you're out of network for starters. And secondly, there's no guarantee that you're going to get repatriated. These international policies are incredibly cheap. They will repatriate you and bring you to the nearest United States hospital. There's another program you can buy for a little bit more money that if you wanted to be flown home from, let's say, St. Martin Island to Chicago or Minneapolis or wherever you might live, that those programs exist also. Anyway, this international policy also had a provision to not only repatriate you if you lived, but you needed medical attention to get home, but it also had a $25,000 benefit to help repatriate the remains of a decedent. And so Barb and her friend were in Jamaica for Saturday and Sunday. Her friend got up Monday morning, went to breakfast. She thought Barb was sleeping. She came back and found Barb had passed away in her sleep. The client's son, who I've known since he was a little kid, called me up, and I didn't expect a phone call. So when he did call, I'm like, "What happened? Is she okay?" And then he explained to me that Barb had passed away, and he was not freaking out, but he was certainly like, "What do I do now?" And he just kind of laid the ball in my court and said, "Go find out what I need to know." And so I did. Came back to him, and I gave him the information that he needed to know. And then I said, you're going to need to contact them yourself, because at the end of the day, they're not going to go through me. They're going to go through you. And since you are her son, you need to be, front and center on this. So he appreciated the work that I did, no different than anybody else in my shoes would do. But these international policy folks are very important. I had another client who did not have one of these, and has had a hell of a time getting their insurance carrier and Medicare to process the claims that they needed to get processed. These international policies oftentimes may require you to pay for things up front, but you'll get reimbursed in the back end. The air ambulance kind of stuff generally will be covered to the extent of the policy limits, but not having an international policy, folks, is a big deal. So I talk about this all the time with my clients during open enrollment meetings and when I have chances to chat with them individually. And you'd be surprised how many people didn't know that these policies even existed. The one thing I should tell you, too, I can't speak to Medicare Advantage plans because we don't sell them. But Medicare, generally speaking, Medicare does not cover international travel. Your supplement may, underscore the word may, cover international travel, depending on the kind of supplement you have. And specifically, you have to have Plan G or Plan F, as in Frank, which doesn't get sold anymore. If you have Plan N, as in Nancy, it does not cover international coverage. To the extent that Plan G does cover international coverage, they will pay 80% up to $50,000, which is not a lot of money, folks, in the big picture, even international. I can tell you, I had another client, this is 15, 20 years ago, had to be flown from St. Martin Island to Fort Lauderdale, Florida. It was a $25,000 flight to get them from St. Martin Island to Fort Lauderdale, and that was just the air ambulance. And by the way, that particular air ambulance wanted $5,000 up front before they would go wheels up. So don't not look at an international policy if you're traveling overseas, or frankly, if you're going on a cruise, whether you're going into the Caribbean or Alaska or Europe or on the other side of the country with Hawaii, for example. Don't not consider these things. On the lighter side, you guys know I'm a Cubs fan. Cubs are in first place, but it's early. It's only May. Let's see where they are in the middle of August if their arms haven't fallen off yet. For those of you who love hockey, this has been a great hockey playoff season. The games have been a pleasure to watch. A lot of games have gone into overtime or have been very exciting towards the end of the game in a lot of cases. But with all that, let's get into it. We're going to recap durable powers of attorney. And I just want to say that this is what we ended off before I was out of town last week. A durable power of attorney, there's two kinds, general and durable power. General power is specifically going to allow you to act on somebody's behalf until they become incapacitated. The moment the person who granted you general power of attorney becomes incapacitated, your power ceases to exist. That is not a power of attorney that should be utilized if you're needing to help somebody who does fall on bad times, becomes incapacitated, or doesn't have the capacity to think on their own because of circumstances beyond their control. A durable power of attorney, on the other hand, is absolutely set up so that in the event of an incapacity on whatever level, that durable power does not cease. It continues until that person passes away. So the durable power of attorney should be handled and should be the power of attorney of choice. I would recommend that any child over the age of 18, including my children, Randy, Ryan, Trevor, and Taylor, you should have your own powers of attorney because you're all older than 18, and there's no guarantee that a medical person will honor me or mom's wishes insofar as how to treat you in the event of a medical emergency. And there are two types of powers of attorney. One is property, which basically allows you to pay bills, theoretically access the bank account if you've got permissions, act on in the general power of the person for the property, the car loans, the taxes, anything that involves your property, and I'm using the word property in a broad way. The second power is a separate power for health care. And it does not include necessarily, but it can include what's called a living will, which basically says, do whatever you can to keep me sustained, or unplug me, I don't want to live this way, or somewhere in between. But a durable power of health care is basically empowering you to manage the health of the person who appointed you as their trustee or executor for power of attorney. These powers can be withdrawn at will so long as the person who issued the power has capacity to do so. Once they lose capacity, they can no longer make any adjustments to the power of attorney, let alone their wills or trusts. You may have the ability to make changes, but I want you to keep in mind, too, that other people might be looking over your shoulder, and there are some legal consequences if you are not doing the right thing on behalf of a third party, which is the person who granted you power of attorney. And I can promise you, when money gets in the way, folks, everybody can be lovey-dovey up until the moment that money gets in the way, and all of a sudden the knives come out. So the person who's issuing the power needs to think through who they're assigning, why they're assigning that person, whether it's a friend, neighbor, son, daughter, mother, father, aunt, uncle, whoever it's going to be. They need to be aware of your wishes. They need to be aware of what you want to have happened in the event something happens to you. And you have to be also aware of the fact that they can say at the last minute, sorry, I don't want this responsibility, hand it over to somebody else, which means that you need a successor in play for these powers of attorney in the event the other person becomes incapacitated or they disavow themselves from it, they don't want to do it. So powers of attorney, in the scheme of things, are probably the easiest things to put together, but likely the most important because you're still alive. You're still 6 feet above ground, not below. And you still may have capacity to be able to make certain decisions, or you may be rehabbing to come out and be able to make decisions. And so the powers of attorney are probably the most important piece to have put together. In fact, when I was leaving my friends in Florida, it's the first thing they said, we at least right now need to do powers of attorney. So that was a good start. So, powers of attorney are not wills. They cease when the person who issued the power dies. They cease. Power no longer exists. Kind of along the same lines as your HIPAA protections also cease when you die. You don't, as a dead person, it sounds kind of funny, but as a dead person, you don't have any privacy rights. There's nothing private any longer. You passed away. Everything is open for scrutiny. And that, what I just said, is going to be meaningful as I get into the wills here in a second. So durable powers of attorney cease upon the death of the issuer of the power, and they can no longer be used for purposes of accessing anything that you had the power to do prior to the person passing away. So, for example, if you are still having to write checks out of somebody's account just to pay bills, if for no other reason, just to pay bills, and you go into the bank and you say you issue the power of attorney, and somehow the person, the banker found out that, Johnny Lunchbucket passed away, they're going to say, where's the death certificate? That they were working with you up until the point where Johnny didn't live any longer, and now they're going to ask for the death certificate. In regards to the death certificate specifically, I would recommend that if somebody says you need 20, get 40 or 50. That might be overkill, but depending on how complex your estate is, everybody and their uncle is going to want a death certificate. Life insurance companies, the mortgage company, the bank, business relationships that you may have, vendors that you are needing to chat with. And if you've got properties in multiple states, it gets to be messy. By the way, I'm going to go back to Barb Sable thing for a second. And when I said that, there's one other little thing that I didn't know about until I found out Barb passed away. When a person passes away in a foreign country, the State Department is now involved. And it's a process, folks. It's not going to be snap my fingers, put them in an urn, or put them in a box, and we'll fly them home. There's a process. And it can take anywhere from 5 business days to a month to get the person back home, depending on the circumstances and the paperwork that has to be put together. And you're at the mercy of the people in the State Department and at the mercy of the people in that foreign country where you are, where the event occurred. So just be aware of that. All right. So let me go back to the powers of attorney and wills and so forth. So you pass away, the durable power no longer exists. You now need death certificates to get access to a variety of different things on behalf of the decedent. Now, you may have power of attorney, but you may not have been appointed trustee to the estate. You were there to make decisions on the person's behalf while they were living, but the person who passed away may be known to you, maybe not, isn't you when it comes to dishing out the estate or managing the estate, as it were, to resolve it, to pay off the debts, to and disperse whatever dollars have to be dispersed to the extent the estate has anything. So be aware that that could happen. In my world, that didn't happen. When my dad passed away, my sister was power of attorney, and then she was made executor by virtue of my dad's living trust that he did. But we're going to talk about wills, not trusts. So, if you have any assets at all, whether it's a bank account, a life insurance policy, cars, house, investments, a business, collectibles, stuff that you've collected over 20, 30, 40, 50 years of life, 90 years, 100 years of life, you have an estate. As I said, I think I said this a couple of weeks ago, if you didn't own anything but a $5 million life insurance policy, your estate's worth $5 million, by the way the law reads. Most people don't have those circumstances. They have stuff. So if you have assets, and therefore you probably have liabilities like credit cards or a mortgage or debt on a car or college loans, you have an estate. So how does your estate get dispersed? How does it get resolved? Are there taxation consequences in certain circumstances? Is there any life insurance or investments or 401k monies or IRA monies that specifically have beneficiary designations? Or do they? Are those beneficiary designations up to speed? Give you an example. So you named your spouse as a beneficiary to your 401k and your spouse predeceased you. You never changed the beneficiary from your spouse. She's not in line to receive any money. She's passed away. Who gets the money? I'll get back to that. Same with transfer on death clauses. Those are typically used by investment houses like Schwab or Merrill Lynch or a variety of other places. Transfer on death clauses. Who gets the money? Are your beneficiary designations up to speed? What state do you live in? And we're coming up against the bottom of the hour, folks, so we're going to finish up this last couple of sentences and go to break. Do you live in a state that it gets split 50-50? That's a community property state. Or do you live in a state that's not community property state? And then how are your assets titled? Are they titled joint tenants with rights of survivorship? And who's the joint tenant? The spouse, child, friend? Do you have the tenancy by the entirety, tenancy in common? Or do you own it by yourself? All of this matters, folks. All of this matters because that establishes the estate. And in the next half hour, we're going to talk about what it looks like to have a will, what it looks like not to have a will, and what it looks like when you have properties in multiple states with or without a will. So with that, this is 101.5 FM, WLCB, Slade's Corner, Wisconsin. This is your Insurance Corner. My name is Bill Miksch. I'm president of WDMA Financial Group in Grayslake, Illinois, and we will be right back after these short messages.